Starting. All attendees are in listen-only mode.
Good afternoon, everybody. I'm delighted to welcome you to today's webinar on exporting for services, specifically what service exporters need to know about IP and VAT. My name is William Barnes-Graham. I'm the digital content at Open to Export, and sorry for being slightly late starting. We are a government-supported online community helping small UK businesses get ready to sell overseas through our step-by-step articles and guides, regular webinars, Ask the Experts forum, and our Export Action Plan tool. You can find all of these on our recently redesigned website at www.opentoexport.com. We will be running a live Q&A at the end of the session today, and you can ask questions at any point during the webinar using the question box on the control panel to the right-hand side of your screen. We will also be reposting relevant questions onto our forum afterwards, so hopefully, in one way or another, you'll get answers to them. We don't typically share slides, but we will be recording the webinar and uploading it onto our YouTube channel, as well as linking to it on our webinars page, where you can also find out about our upcoming webinars and listen to previous sessions. We have three great speakers today. Kicking things off with guidance and tips for protecting IP overseas will be Bill Russell from the Intellectual Property Office. And following Bill, Liz Maher from Centurion VAT will give an overview of everything service businesses need to know about VAT. And we'll then finish off with a case study, Turtle Tots, an innovative aquanatal yoga and baby and toddler swimming program franchise, and also a previous finalist at one of our Export Action Plan competitions. But to begin with, over to you, Bill.
Thank you. So, quick introduction. My name is Bill Russell. I'm head of the Global Cooperation team here at the Intellectual Property Office. Can I have the next slide? And just to give you an oversight of who we are and what we do and why IP is important. So we are part of the Department for Business, Energy and Industrial Strategy, and we do both the rights granting, that's for patents and trademarks, but we also do the policy making function, and we have an enforcement arm as well for IPRs. About 850 staff. Our main site is down in Newport, but there's a small team here in London. As it says there, our main task is to help stimulate innovation and raise the UK competitiveness through the use of intellectual property. Thank you. For the next slide. So I'm going to start off by saying what intellectual property is, because if you don't understand that, then the rest of it is going to be a little bit confusing for you. And I'm going to focus on the ones which are more related to service industries than some of the others. So in the UK, there are a number of types of intellectual property. The key ones are up there, which are copyright, designs, trademarks, and patents. And the thing you should be very aware of is that they all work in different ways. Some you have to pay for, some you don't, some are automatic, some have to be registered, some can be both, either registered or unregistered. And they all work in different ways and cover different things. So you have to find which ones are the most appropriate for your business. And I would say look at more than one layer of IP protection. If you think of IP protection as that layers of protection, there are various things you can do to add extra protection for you and your company, particularly when you're looking at overseas markets. So to very, very quickly go through the four main types. The main one, the first one there is copyright. And copyright is free and instant. You don't have to pay for it. You don't have to register it with anybody. You don't have to log it with anybody in the UK. The way you do it, it's the little C mark as demonstrated there with a date next to it. The C just says copyright. The date is the important thing. The date is the date of creation. What you're saying is on this date, and I would do it in that format, on this date, I created this. It belongs to me. If you want the right to copy it, if you want to use it, then you have to ask for permission, the right to copy. That's what copyright is. And copyright covers all sorts of rights. It covers music, web pages, artwork, film, anything where you have created a thing. And it covers for life plus 70 years. So you can assign it to other people. You can, when people ask to use your copyright, you can say yes, you can say no, you can say under certain conditions, you can franchise it, you can use copyright like an asset, like any other part of your business. And just to repeat, it is free and it is instant. anybody who tells you need to register it in the UK, that is wrong. In some overseas jurisdictions, India for example, you do have to register copyright. But I'll come on to the differences overseas in a little while. I'll skip down to trademarks if I may for the next one. Trademarks come in two types: registered trademarks with a little R symbol with a circle around it, and unregistered trademarks, which in the UK have a little TM next to them, or nothing at all. And trademarks cover brands and logos and signs, and they can last forever in the UK. The first trademark granted in the UK, which is the red triangle on display there, that was for Bass beer. That was back in 1870, and that trademark is still in play today. As long as you keep using your trademark, you can keep it forever. There are renewal fees, but they are not extensive. To register a trademark in the UK takes £170 and takes about 13 weeks. We have one of the quickest IP offices in the world for that. But once you have a trademark as a registered trademark, no one else can use that brand or that logo. You have exclusive rights in the UK. If you want to extend that to overseas markets, there are things you need to do, and I'll talk about those in a little while. Design rights, they work in a similar way. You can have unregistered design rights, which you don't pay for, you just use, or you can have a registered design right, which is you pay for, and it gives you exclusivity to that. That covers the way that products look and their layout. In the UK, design rights last for up to 25 years, and it costs about £60 for the first one and £40 for each subsequent application made at the same time. So if you have two design rights that you're registering for, it would be £60 for the first one, £40 for the next one. The last one, which I won't cover in any particular detail because it's not really relevant to services, is patents. And patents are for inventions. Patents cover up to 20 years, and they give you exclusivity for that idea, that innovation in the UK. Patents are usually for things which have an industrial application. Unlike many countries around the world, the UK does not have patents for things like software. We use copyright to protect that, which is free and instant. So there are advantages and disadvantages around the world, but for software, we use copyright in the UK. Other jurisdictions, you might be looking at software patents. Okay, I'll cover that slide. Can I go on to the next one then, please, Will? So why should you be bothered? Why would you care? Why is IP important? Well, IP rights effectively give you a monopoly, exclusivity for using your ideas and your creativity. It means that no one else can use them without your permission. But IP is often a company's most important, but probably one of its least protected assets. When companies buy up other companies, or when companies look to engage with other companies, what they're looking for primarily is their branding, their logo, their name, their footfall. Then it's their innovation, then it's the products that they produce. That is all intellectual property. And if you haven't protected your intellectual property, chances are, particularly when you're going overseas to markets which are far more IP savvy than the UK, you will find that your IP could be taken from you, stolen, used without your permission. But if you've done the right things in advance of going overseas, your protection will be greater, your ability to protect your assets will be greater, and your ability to get those assets back if they are used inappropriately will be substantially improved. So doing the right things at the right time in the right way is very important. Go on to the next slide then, please. So a little bit about IP awareness. We've been doing IP rights in the UK for a long time. I think the first patent in the UK was actually back in the 1480s, so a long time ago. But despite that, IP knowledge in most UK businesses is pretty low, I would say. Only about 5% of UK businesses have any overall management strategy for their IP assets, even though they may be their most important ones, and they don't know about disclosure. That's particularly important for inventions, for patents, where if you talk about them before they're registered, effectively they have been disclosed and you cannot get a patent in the UK. That's a really important thing, but I'll focus on that in another talk when we're talking about patents. If we can move on to the next one then, please. So IP awareness in the UK. Although IP is a really important asset for a business, about 1 in 4 UK businesses tell us they will not go overseas because they think that their IP assets are likely to be taken or used inappropriately. And therefore, it's part of our job, that's why I'm here now, to try to get you to think about the things that you're likely to encounter when you go overseas. So the first one is that IP is territorial in nature. So IP rights registered in the UK, be they patents or trademarks or designs, are only registered for the UK. If you register them in another market, it will cover that market. So IP is territorial. There are ways you can extend that overseas, and I'll cover those later, but it's important to recognize that there is no such a thing as a worldwide patent or a worldwide trademark. It just doesn't exist. IP is pretty much territorial. The second point in there is that IP is first to file, which means that if I get there before you do, if I register it before you do, it pretty much belongs to me and not to you. And that doesn't matter whether you've been operating as that company for 10 years or 110 years. If I register the rights before you do, it pretty much belongs to me. And that can have a big problem. The biggest one is what we call trademark squatting or brand jacking, and that's where businesses are looking for companies who haven't registered their trademark yet. And what I then do is nip in ahead of you in the market, find out where you're going, nip in ahead of you, register that brand in my name, and then when you arrive in the market, I'll present you with essentially 3 options. Option 1 is to bring your lawyers and I bring my lawyers, but I've done nothing wrong. It's a first to file system. I intend to use the trademark. Chances are I will win the case regardless. The second option is that you rebrand, so you have to find a new name and you start again effectively. But I've now got access to your customers. When your customers are now looking for you, they will find me. So that's not necessarily a cheap option either. And the third option, which is what most brand jackers want, is they'll say, okay, give me £5,000 or £10,000 and you can have your brand back. That is by far and away the biggest issue that we find for businesses going overseas, particularly service businesses where their name is their most important asset. That is the thing that we'd say you must protect most. The other thing it says in there is that IP systems can be very complex. They can be, and it can be really difficult to navigate. And enforcing your IP rights overseas can be really, really difficult. And the alleged infringers have home player advantage. They know the system, they know the laws, they know the language. It can be very difficult. Next slide then, please. So what are the big issues you're likely to face? Well, backlogs. Backlogs are a big issue around the world. I've talked about how quickly you can get a UK trademark in about 13 weeks. If you're going to some markets, it can take literally years. Brazil, for example, a trademark application will last probably 4 years before it comes through. So you can be waiting a long time for some of these rights to be granted in overseas markets. There are ways around that, and I'll come to that in a minute. Trademark squatting I've spoken about. Patent trolls are very similar. They buy up patents, but I'll cover that in another conversation. Online piracy and fraud, well, you'll all be very aware of that as customers of the systems. It's a big issue around the world. And I'll go to the last one there because time is running away with me. It's changes following Brexit. There will be changes to the IP system. Those who have got community trademarks, which are European-wide trademarks, there will be changes to that. We don't know what those changes will be yet. We're still going through the process of thinking about it, and that's going to be part of the negotiation over the next 2 years. But there will be changes. Next slide, please. Okay, so my top 3 tips are: know before you go. Know that the IP rules are different around the world and they vary significantly from country to country. Understand that IP is territorial. Understand that it's a first-to-file system in most parts of the world. So act fast or miss out. Next slide, please. So what I've got on here are some of those treaties that I talked about in ways of extending your trademark or your patent or your designs overseas. The Madrid system is a system operated by WIPO, that's the World Intellectual Property Organization, that allows you to extend your trademark to many countries around the world. Patent prosecution highways and patent cooperation treaties do something similar for patents. For copyright, there's something called the TRIPS agreement, which means that most countries around the world understand and respect copyright. But the way you actually assert that right, the little C mark in the circle and date, is different from country to country, so get advice. Next slide, please. So to help you, we've done a whole range of things which will hopefully answer many of your questions. We have things like IP audits and health checks and masterclasses. We have country-specific advice using the website link that's there. We have business guides for 6 countries. And in the most important and difficult markets, China, India, Brazil, and Southeast Asia, we have IP attaches there. So I'll cover those very, very quickly on the next slide, please. So there are IP attaches, and so they cover China, India, Brazil, and Southeast Asia. A little slide next one about what they do. So they give one-to-one business support. So if you're going to those markets, they're a free source of advice. I'll repeat that. They're a free source of advice. If you contact them, they can give you advice on the local systems, what to do, what not to do, where to go, what not to do. They also do IP awareness raising, getting people to think about their IP assets. They are very, very good. They are local experts in their IP field, so please, please use them. They're already paid for. Please use them. Have the next slide, please. And this is just the links to the attaches are at the top. That's their contact details. But we also have UK-based offices and helplines available that cover most of the geographies. The one I'll point to most relevant there is the one right at the bottom, the free phone number. If you ring that number, they'll either put you through to the appropriate person, or if you have questions about any of those markets, they'll put you through to the right person. It's a very good system, so please, again, it's paid for, it's a free phone system, use it. On to the next slide, please. And that's it. I hope that's covered it. If there are any questions, I'll be happy to take them at the end. Back to you, Will.
Thank you, Bill. And yeah, as you said, we're getting quite a few questions in on IP already, so we'll be coming back to some of the points you were making at the end. But yeah, thank you for a really great overview of IP and services just then.
Thank you.
And now we're going to move on to Liz, who's going to cover VAT.
Thank you, Will. Yes, welcome to the wonderful world of VAT, everybody. If you could click onto the first slide for me, please, Will. Now, VAT is a simple tax. It's a simple question of identifying when you should be charging it. What I wanted to touch on first, and this sort of interacts with one of the questions we've already received in regard to what happens in terms of Brexit, is to make sure everybody actually understands when we're talking about the European Union, what are we actually talking about for VAT purposes. Now, we're a member of the European Union, and that in itself, as you can see from that slide, means we are a member of the single market. So when we're talking about the single market, you hear that term bandied around a lot. It actually means something very specific for VAT purposes. It means that we can access a set of specific VAT rules which govern when and where we should be charging VAT. So therefore, if we are to leave the single market as the UK, we will be leaving the member states, the 28 member states, and we will then have to consider what the impact to the VAT rules for us will be, whether that's for goods or in services as we're talking about today. So next slide. If you look at the next slide, I've just put together a couple of the basic rules so that for those of you who are unfamiliar with VAT at all can understand how VAT interacts in the European context. Because we're part of the single market, it governs the minimum standard rate that we can set, so it can't be less than 15%. It also governs whether we can have reduced rates, etc. But it also governs where supplies will be taxed. And the role of international services is complex because it's impacted by the nature of our customer, whether they're a business customer or a consumer. Secondly, it's impacted by where that customer is based. And thirdly, it's impacted by the nature of the service that we're providing to that customer. So there are 3 steps if we're to identify what the VAT treatment of our supply of international services are. If we turn then to the next slide, I've just put again in there the basic VAT rules. So if I'm going to end up saying, for example, oh, your supply is subject, it's a place of supply that's happening in the UK, then it will be subject to the UK VAT rates. Now that will normally mean it will be subject to 20% VAT, but there are other VAT rates, and sometimes you do have to look at, particularly in regard to training, whether you might be able to access a different rate, a VAT exemption, or even a zero rating in some instances on some training. So that slide just gives you those basic VAT rules that we're all dealing with. So let's look at the next slide, which deals with these international services. And as I said, it's impacted by who is your customer. Is this a business-to-business supply that you'll be making, or is it a B2C, a business to private consumer? So it might be that you're in the business of selling apps, or people can download content and pay for that content off your website, perhaps a subscription service, or perhaps an e-book. All of those, if they're being purchased by Joe Blogg's, private individual, is where we would be talking about it being a B2C supply. A business-to-business supply is where we're talking about not necessarily to someone who is VAT registered in another European member state or is a business elsewhere, but it might be that they're a charity who has business activities. So they might fall to be treated as a business-to-business supply because although they've got non-business activities, they're actually in business in the country that they belong. So all of these three steps that you see on that slide, the nature of the service, who the customer is and where that customer belongs, are all steps that we need to talk about in order to determine what the VAT treatment of a supply is. Is it deemed to happen here in the UK, or is it deemed to happen outside of the UK? And if you think of it logically, if this place of supply is outside of the UK, then it's not going to be subject to the UK VAT rules. It will be subject to the VAT rules in the country where it is determined to happen. Now that country might be a European member state, in which case what VAT rules do we look at, or it might be a country which is outside the European Union. And the place of supply is effectively saying, if it's saying where that supply is, if it's outside the European Union and outside the UK, then clearly it's outside the scope of VAT in its entirety. If you then turn to the next slide, what I've done there is put up the place of supply rules as it would impact if the supply was deemed to happen in the UK. So depending on, and we'll look at the general rule that will help us do that, but that's clearly just to remind you that not everything might end up being standard rated, even though the place of supply is happening here. We have to look at, well, what is the service that's being supplied? Is it always standard rated, or can I use another liability? So I think it's really important now to look at the place of supply on the next slide in terms of the context of it being an international supply. Now the phrase there that's in bold is the phrase general rule, and that is, a specific meaning. It means the general rule that we're going to apply to the treatment of services if they're deemed to be happening across an international service base is what's listed on this slide. So the general rule that we'll follow as a UK business is we'll be looking at, is our customer a business that we're supplying? And the general rule for a business-to-business supply of services will be where that customer is established. So if we're in the UK and our business customer of our services is in France, then the place of supply of those services will be France. And that means when we raise our sales invoice to them, we will not charge them UK VAT. But as you see from the first bullet point, what will happen is that the customer will charge themselves VAT in the country that they are based. So someone somewhere in the European Union has to account for VAT. And these place of supply rules are saying, well, if it's not going to be the UK supplier, then it will be the European customer under this reverse charge mechanism. Now equally, as you can see from the second bullet point, if the customer is established outside the European Union, then what we're saying, okay, the place of supply rule is still the same, it's still where the customer is established, but if they're outside the European Union, that means the supply happens outside the European and the UK VAT rules. So you wouldn't, again, be charging them UK VAT if they're based in Japan, but you would need to look at the Japanese indirect tax system to see if it creates a VAT registration for you in that country. It's really important to recognise that VAT in the UK is not just a European tax. It's not just a tax system that works in 28 member states. It's actually a tax system, a transaction-based tax system that operates in about 115 countries around the world. So you do have to think about what are the VAT rules in India, in China, in Australia. If my place of supply is determined to be there, do I have to appoint a fiscal representative, be VAT registered there, and charge Australian Chinese VAT. Okay? So the general rule for B2B is there. The general rule for a B2C supply is, again, the place of supply determines where the supply happens for VAT purposes. The place of supply for a B2C supply is where the supplier is established. And that means if I'm a supplier based here in the UK, even if my customer is in France, if they're a private customer, I will have to charge them UK VAT on the nature of my supply to them of services. Now, there are different types of services that we need to understand, but those are the two core rules. What you then have to consider on the next slide is a list of services which do not follow this general rule. So if you're looking at those bullet points on that slide and thinking, hang on a minute, my services are in there, then you do have to do a bit more work, because they will not follow the general rule treatment, whether they're business to business or business to consumer. This is an area where you need to check. And it's interesting, isn't it, that one of the bullet points up there, it talks of intellectual property, trademarks. So even, you know, this connectivity between Bill and myself, you know, does come into play. Now, people have asked some questions about training, and that is clearly going to be one of the areas that you will have to do a bit of work on to understand, is this an educational service that I'm providing, or is it an e-service? So again, that's about you understanding the nature of your supply of services and how it will be treated for VAT purposes. Just to give you a for example, in terms of talking about e-services, if you look at the next slide, I've just put a couple of bullet points up to give you a flavour of, well, what do we mean by an e-service? And that's going to be an electronically supplied service that is basically, there's very little human intervention. And I'll stick with training as an example. You know, if I'm providing an online training service, am I providing that because people are, like now, logging on to a live webinar and they are engaging with us directly and receiving education and questions are going back and forth, then that's not going to be an electronically supplied services within this definition. It's delivered through an electronic means, but it's not an e-service. That would be different from somebody in the middle of the night logging on to a pre-recorded educational program and choosing to download and watch the video at 2 o'clock in the morning and to answer the questions online and get immediate answers back as to how they're doing, because it's, you know, a software program is carrying out that examination. So you do need to understand exactly what you're doing. More common examples of electronic services, you can see there, information, downloaded games, music, you know, books, etc. So that's illustrating how you do need to understand exactly what you're providing, because if you then look at the next slide, so what we've said is there's a general rule for services. That general rule doesn't apply to all services. Electronically supplied services are an example of where it's a bit different. You need to understand if you are providing electronic services, and then if you look at, well, what are the VAT rules if I clearly am providing electronic services, you can see here that again we will revert to B2B or B2C as a differentiator, but in the B2B context the place of supply is still where that European customer belongs, and the customer would still account for VAT using the reverse charge. So that's no different from the general rule. But where it changes is on the B2C supply, because it's subject to VAT where the EU customer belongs. Now that is different from the general rule, because under the general rule for B2C supplies, it was where the supplier belongs. Now that indicates, therefore, if you're involved in these electronic services or other services that are caught under a different rule, you might have to be charging overseas VAT even if you are a UK-based business. Now, for electronically supplied services, there is a mechanism to help you account for that. You don't actually have to be VAT registered in all the countries of your private customers, your consumers. There is a system called the MOS rules, Mini One-Stop Shop. So I would encourage, for those of you who are involved in these types of electronically supplied services, you look to the MOS system. and the MOS is specifically there for these e-services. It's not there for anything other than that at the moment. If you then look at considering other services on the list, for example, one of the bullet points was services in relation to land. You might be an estate agent and you might be acting for a customer in France who wants you to sell their property in Germany. Now, the general rule again doesn't apply for that purposes, because in land-based services, it's where the land is based that determines the place of supply. So if the land is based in Germany, okay, you're a UK estate agent, but you should actually be charging your customer German VAT, because that's where the supply is taking place. So I haven't got time to run through all the different variations of deviating from the general rule. I've just concentrated on electronic services because that's a particular growth sector in the UK. But do go back to that list of all the odd type services and make sure you understand where you are. Particularly land. It's not just about selling land, it might be about you installing equipment in land overseas, or carrying out services, geographical or geological surveys on land, or designing buildings. These are all aspects that might be drawn into the services related to land category. So just to consider what it might look like post-Brexit, because these are all the rules that we access through our membership of the European Union. And as I mentioned at the outset, if we leave the single market, we're effectively, unless somebody negotiates us back in for the VAT section alone, we'll be faced with, well, what are the place of supply rules going to be post-Brexit? Now, normally when we have seen situations like this arise in the past, what we have seen is countries having stayed outside, Turkey is a good example, having stayed outside the European Union for VAT purposes, they have still mirrored within their indigenous legislation the same type of place of supply rules. So it might be that we end up in exactly the same position as we are now. But with things as they are, I'm not putting money on anything at the moment. And I think for us as service providers, we need to be just aware as to this is what the rules are now. They may change. We need to get up to speed with the rules as they are now, and we need to keep our eye out as to what the rules might look like going forward. So that's a very quick run through VAT and international services. And it is quick because normally it would take me half a day to do a training session on that. But as Will and Bill have already said, if there are any questions, then do come back to me. My 3 key points in terms of knowledge to take away is identify who your customer is, know where they are physically belonging, and know what your service is in terms of its VAT treatment. So that would be my 3 key tips to go away with from today. So hand back to you now, Will.
Thank you, Liz. That was a really excellent presentation. Lots covered there, and yeah, we're getting lots of questions in, so hopefully we'll be able to go back to VAT a little bit at the end. We're now going to hand over to Caroline from Turtle Tots, who's going to talk about her experiences as an exporter in a franchise business. So over to you, Caroline.
Hi. Hi, my name's Caroline Sparks and I'm one of the co-founders of Turtle Tots. If we could have the next slide, please. So we are a company that runs a program of aquanatal yoga and baby and toddler swimming. We launched in 2011 and we franchised the Turtle Tots program. We currently have 45 franchisees, and that includes one in Ireland who launched in 2 years ago, and also one in Melbourne, Australia, who launched last year. I put 50%, but actually it's 60% of all our franchisees began their Turtle Tots journey as a customer. So we find word of mouth is a very powerful tool for recruiting franchisees. So much of our growth has been very organic, and that actually includes the 2 international franchisees we've got. One of them is the brother of one of our UK franchisees, and the other one in Australia is a friend of a friend. She's British but married to an Australian. So we can have the next slide. So why did we want to internationalise? It was always our plan from day one to internationalise. In the UK, there are a lot of baby swimming companies, and we obviously need pools to teach swimming. Getting pool time is very difficult and is kind of one of the main things that it can be very challenging for our franchisees. So we realised that there are many other countries in the world where pools are much easier to find and where baby swimming isn't as popular in the UK because the people there don't realise the many benefits. So diversity reduces the risk for us. There's no worldwide baby swimming brand, and we have the capacity to manage to launch in other countries. We have a team of 10 at our Turtle Towers, as we call it, and the staff capacity to grow internationally. And obviously, we run a business, so it's all about profitability and revenue. So one of the main reasons for internationalising is to increase both of those. You can move on, please. So just really a bit about our experience and some, as I've been listening to this, just writing a couple of tips down really that I think would be useful for anyone considering internationalising. Over the last 3 years in particular, we've worked closely with the UKTI, Open to Export, and companies like Enterprise Nation to really get as much advice and information as possible about exporting. One of the things which I've mentioned at the end of the slide actually is we were finalists in Hewlett-Packard's Going Global Awards a couple of years ago, and we actually won a trade mission to China. Having been on that trade mission, which was organised by Enterprise Nation, I would really advise people to look at what trade missions are available through Enterprise Nation and people like Santander Bank and the UKTI, because they are a really great way of visiting your possible chosen export market in a very cost-effective way. We have trademarked in our chosen markets, so as a result of working with the UKTI and Open to Export, we've identified certain markets that we want to export to, and we've trademarked in those markets and bought the domain names. Again, we have found, we have a solicitor for our day-to-day business needs, but for our trademarking we actually have used a specialist patent and trademarking solicitor, and we've found that to be a much more cost-effective way of trademarking. And last year we also changed our bank account. We were previously with a bank that couldn't really accommodate multiple currencies, so we've moved away to a new bank where they're much more set up for having different currency accounts. So really for us, just kind of coming to a conclusion, we have a CEO who is starting in May this year. We have realised that we needed someone with import-export experience, and he has a huge amount of that, so that he'll be starting in May and knows what our franchise and export plans are. So far we've been fairly reactive on our exporting. The 2 franchisees we have internationally have come to us, so we are planning to be much more proactive in terms of franchise expos and looking at what marketing we can do, particularly in Australia and Ireland, where we've obviously done quite a lot of the hard work in terms of the trademarking, the franchise agreements, the legal work, the website. So we want to now attract more franchisees in those countries. And then the final target that we have is to launch in a 3rd international market by the end of next year. We're in early talks with a franchisee in the USA and also one in Canada, so hopefully one of those will come to fruition. So that's just a really whistle-stop tour of the experience that we've had at Turtle Tots, and which I hope might be of interest or useful to people, and I'll hand back to Will.
Thank you, Caroline. It's especially great to hear a case study of a company you've worked with before through our competitions, and yeah, it's very good to hear from an underground exporter. Um, we've had a heck of a lot of questions come in, and obviously they're kind of split between VAT and IP mostly. So I was going to go back to Bill quickly with a question on IP, and the first one is from Barbara. And Barbara asks, how do you check if a company name is already trademark registered in a particular international market outside of the UK? Over to you, Bill.
Okay, there are a number of databases available. We have one in the UK, which is on the IPO's website. There are ones on the European IP offices' websites as well. So there are a whole raft of databases where you can go in and check whether there's a trademark's been done either as a word mark, i.e. it's a word, or a graphic mark. So it can be a picture or a graphical image. There are a whole raft of ways of doing it. You've talked about using lawyers. There are trademark lawyers who can do that for you, or you can do it yourself. If you come onto the IPO website, there's links on there that will take you to most of the biggest databases around the world. Hope that's helped.
Thank you, Bill. And another question on IP. This time it's from Sven. And he's just asking for a bit more kind of detail about the Madrid Protocol and the Hague Protocol in theory and reality. He's asking kind of what is the effectiveness of these in international markets and outside of the UK and EU as well.
Okay, I would argue that both the Madrid system and the Hague system are really good ways of having a brand or a design in one market and extending it to multiple overseas markets. The advantage they have is that you can do it in one hit, in one language, whatever language you find most useful. So you can do it in English. You pay one fee. You pay a different amount for each country. So if you're looking at doing every market around the world, that will cost you a lot of money. So choose your markets carefully. But it is a really effective way. It's as effective as going to the individual trademark and design officers and asking for a separate trademark. It's just a quicker route of doing it. So there are a number of options that you can use, but I would say the Madrid system and the Hague system are as good as any, and they allow you to do it in one application with one fee in English. That's probably what you find most useful.
Thank you, Bill. I'm going to do a couple of questions with VAT now. So one from Andrew, and he's asked, if we sell a UK-based package to an international corporate client, it's supposed to supply in the buyer's country if the package is a combination of hotels, activities, transports, guys. So I guess that one's for you, Liz.
Okay. Well, you've mentioned a few different things in there in terms of selling a package. I think if I was to talk about what services are accepted from the general rule, if I'm selling hotel services, I've got a hotel based here in the UK, then clearly that is a supply that is a service relating to land, so that's excluded from the general rules. So if I'm selling rooms in a hotel in the UK, and that hotel's in the UK, then that's subject to UK VAT because it's a service relating to, hotel rooms are here. So I suppose there's a different sort of side if it's intermediary services and you're a booking agent and where your customer is. And that would also lead me to want to understand how you're making that sale. In terms of online activities through a website with automatic booking on websites. So there's a whole list of questions I'd have probably to ask you, Andrew, if I was to come back with a really clear answer that you could rely on, shall I say.
Thanks, Liz. And yeah, we've had a few kind of quite specific questions about VAT, and as mentioned at the start of the webinar, we'll try and get to some of those on the forum afterwards. We'll try and keep things a bit more general for now. So a good question we've had which has just come in, and it's from Pete. It's about VAT on digital online services. His example is online training, and he's asking, are there any recommended kind of commercial products available for automating VAT costs based on where the customer is based? He's heard Taxonomy is quite good. So what thoughts on automative kind of processes?
Automated process. Well, I would have to, Pete, I'd have to defer to IT people on that one. Obviously, we're a VAT advisory firm, so I can't actually point you to a recommended sort of IT supplier that's got a good package. I think you'd have to perhaps talk to the industry sector or look at organisations, whether the Chambers of Commerce have got sort of a database of people that they could point you to. I don't know, but that isn't really something that I'd be in a position to answer.
Thank you, Liz. And a question back to Bill. It's from Caroline at the wonderfully named Raising the Bar, and she's asking, copyright versus trademarking. Is it wise to have both if you're on a limited budget, or should you do one or the other?
Okay. Trademarks, as I say, the presentation come in two sorts. You can either have a registered trademark or an unregistered trademark. An unregistered trademark costs you nothing. Copyright, as I said in the presentation, is free and instant. It doesn't cost you anything. What you need to do is assert that right by using the little C mark. So I would say think of it as layers of protection. Copyright is probably your base protection. It's the one which is most widely understood. It doesn't cost anything and will give you protection so long as you can prove that on that date you created that, whatever that is, be it a poem or a graphic or a piece of kit or whatever it might be. So as long as you can prove on that date you created it by having an auditable trail, by showing how you got to that creation, I would say that's the basic thing. Trademark, have on top of that, either as a registered trademark or as an unregistered trademark. The advantage of a registered trademark is it gives you complete exclusivity in those markets. If you rely on an unregistered trademark, the fear is that someone, because of the first file system, can get in ahead of you, register that trademark and actually take it away from you. You'd have to rebrand, have to get another name. Does that make sense?
Yeah, I think so. Thanks, Bill. And another question for you, Bill. It's from Mandy, and the question is it's the inevitable Brexit question, which you alluded to, and she's asking, in view of Brexit, would you advise a European IP protection or one specific to the country one is planning to export to?
Okay, so for Europe, the picture is slightly more complicated, and it's even more complicated now with Brexit, because in Europe you have effectively three options. You can go to individual country by country, so you can get a trademark or a patent or a design right in the UK, and then you could go to the French office and go to the German office individually, for example, or you could apply for a community trademark or a community patent, which would cover pretty much the whole of Europe. Or you can use those international treaties that I described, which are the Madrid system or the Patent Cooperation Treaty. Now with Brexit, we think, the word think, that patents which should be fine. If you still want to patent within Europe, you will still have access to the European patent system. But the European trademark system we know is going to have to change, and we don't know what that's going to mean for the future. That's still part of the negotiations. So at the moment, I would say it's an informed business decision for you as a company to decide whether you want to do it country by country or use the international system, the Madrid system, to get protection, which you can do for the whole of Europe just by ticking the appropriate boxes on the Madrid pull-down menu, or alternatively, but with a risk, use the European system at the moment, because we just don't know what's going to happen on that one.
Thanks, Bill. And another question for Liz, another one from Barbara, and she's just asking about the MOS system. She's asking how do you access it? So just a bit more info about the MOS system would be great, please, Liz.
Right, the MOS system is available to you through the government gateway, and effectively what it is, it's a VAT declaration form of your sales in those other European member states. So you don't put these transactions on your UK VAT return. In fact, it might even be that you're a UK business who is not VAT registered in the UK, but you have to account for VAT in France and Germany because you've got customers there. So unfortunately, when these rules came in January of 2015, it did, despite a lot of promotion by, you know, VAT people like myself, it did still catch a lot of people on the hop. So the way, Barbara, to get hold of and to access it is through the government gateway. It's effectively your VAT return for sales in that country. The government will then pass over the VAT you've collected at the VAT rate in force in Germany, France, etc. They will pass that over to the revenue. In terms of any input tax recovery, VAT on your costs as a UK business, you would be recovering that through your UK VAT return. So it's very much just a mechanism for passing over the VAT you've got to account for on the European country sales on a country-by-country basis.
Thank you, Liz. And I think we're probably going to wrap up there. We've had more questions in, but they're quite specific. So I think the best way to follow those up would be on the forum, and maybe through email as well, if possible. So yeah, thanks everyone for the questions, and thank you, Bill and Liz, for the answers. Really useful Q&A there.
Thank you.
Thank you.
And yeah, on that note, we're going to wrap up. So thank you once again to Caroline, Liz and Bill. Some really great presentations and hopefully a good overview of some of the challenges and opportunities as well for exporting as a service business. I would like to remind you that we will be posting these questions onto the forum in the aftermath to the webinar. So please do keep your eyes peeled for these, or let us know if you'd like to withdraw your question from this process. Our next webinar is on digital exporting with SDL Managed Translation, covering what you need to do to ensure your offering is understood online when selling it overseas. SDL will be joined by Yale and another case study in Special IAPS, who are also one of our previous finalists. So that should be a fascinating session for sure. That's all from us for now. Please take our survey as you exit to let us know what you thought of the webinar and to give us any suggestions for improvements and future topics. For now, that's goodbye though. Thank you everyone.